All right, so welcome everybody. We're going to talk about record clearing drafting today. Um, so here is my information in the event that you do need it. My email address is here along with my phone number. And this is just a brief outline about what we're going to discuss today. We're going to first do an overview about criminal record clearing in Texas, a brief discussion about what record clearing is and basically how you can be eligible for it. Then we'll discuss petition drafting. We will go ahead and explain how the clinic is going to work, show you some template documents of which you're going to use, discuss how you're going to be able to use that information to draft the petition. Um, and then lastly, we're just going to talk about some ongoing volunteer opportunities that we have through our pro bono program in the event anyone is interested in participating with us. So part one, criminal record clearing in Texas. So we have a little quick question. In 2022, the population in Texas was actually it's a little more than that, but about 28.6 million. And how many of these Texans actually have arrest records at this time? You can put in the chat which one you think. I'll allow everyone to have a little bit of an opportunity to do this, and then we'll go on to the next answer. So over 9 million Texans have a criminal record in Texas in 2022, according to DPS. And this is in regards to having a criminal record that has not been sealed or expunged in this time period. So having a criminal record, first off, let me explain what a criminal record is. We use that term kind of loosely, what a criminal record is, but what it is, it's an all-encompassing term that means there is a record of any interaction that one has had with the criminal justice system, starting from the arrest. So if there's an arrest, there's a record for the arrest. If there is if the prosecutor pursues it and they file charges, there's record of that. There's record of the court interactions, record of any pleas or deals. All of that is a criminal record. And if qualified to either seal or expunge, which we'll discuss momentarily, those documents are going to be encompassed in the order that the court will issue. Now, having an arrest record or criminal record has a lot of collateral consequences. First off, just the arrest itself is not the whole story. You can have an arrest and maybe they never even pursued the charges. The prosecutor decided that they didn't want to proceed. However, you still have this cloud hanging over you because you have an arrest. And you can be judged in the court of public opinion simply because you have an arrest record, even if nothing happened. That arrest record can mean you did go to, they did proceed with charges, maybe they dismissed it, maybe you had a settlement, whatever it may be, you still have the collateral consequences that are associated with that. And those collateral consequences can include anything from having a hard time getting a job, having a hard time getting housing. All of these things can take place and affect millions of Texans. So in Texas, this is a petition-based system. It is not an automatic process. A lot of times we have clients who don't realize the eligibility requirements for record clearing. And I'll explain to them that they'll be like, oh, well, I got this case. I have a conviction. I want it off my record. Then I have to explain to them that it's likely that they're not eligible for anything. But they have this one case that got dismissed and we can get that expunged. And then they're like, what do I care about that? It got dismissed. I think in their minds, they feel like, oh, it's got dismissed. The court doesn't have any access to it, or maybe it's cleared. But that is incorrect. It is not an automatic system. It is a record, it's a petition-based system. So answer this question. In a petition-based record clearing system, blank amount of eligible people are successfully get their records cleared. It is 6.5% of people successfully get their records cleared. And that has a lot to do with a lot of the barriers that are associated with record clearing. First off, you have to know if you're eligible or not, and a lot of people don't have a full understanding about their eligibility rights. Second, there's a fee that's involved in filing a petition. There's also a fee involved if you are going to hire an attorney that's not going to be a pro bono legal service provider. So many people don't have the ability to do that, or the time, or life gets in the way. So many people don't even try to apply to get their records cleared. Also, record clearing takes time. Once a case is accepted by the attorney, it can take up to 6 months to get an order of non-disclosure or expunction signed if you're eligible. There's a lot of factors that are involved in this time period. So it could be just the case is accepted by the attorney, but now you have to go ahead and gather the records. That can take time because sometimes some records are on online portals, but some records are not. So you have to deal with the district clerks. Then you have your client has to go ahead and fill paperwork out, sign stuff, review it. So you need to be able to get in contact with them. But once that's said and done, and you file it with the court, it's now on the court's timeline. So that can be a little bit problematic too, just in terms of speeding things up. So once an expunction order is actually signed by the judge, it will be distributed to the various agencies that have access to one's record, and we will go ahead and explain that in a minute. But those agencies will have up to 1 year to destroy the records. And for a non-disclosure order, the agencies will have 2 months to disclose the record. So now that we've explained how much time they have for each, let me just briefly go into a little bit of detail about what is what. And we'll go into more detail about what you can be eligible for. But in Texas, there's two ways in which you can clear a record. And we use that term clear kind of like a term of art. But in Texas, you can clear your record either through the expunction process or the non-disclosure process. The expunction process, if granted by the court, that order basically will wipe out any record of that offense and make it as if it never existed. While the non-disclosure process, it just seals the order. It doesn't destroy it. It just seals it and makes it so that it won't be able to be viewed by most parties. And we'll go into more detail. But like I was saying, these are some of the barriers that having a criminal record can impose on someone. It could give you a hard time regarding public assistance, getting housing, public or private housing. And also it has employment opportunities, could be taken away from someone because they have a record, including educational opportunities as well. So this is just one of our clients' stories talking about their experience with having a record and how it has impacted their life. So I'll just leave it up on the screen for a second for people to hear. And this is another one of our client testimonials too, to explain how they've been impacted by having a criminal record and how important it was to be able to be assisted with getting it cleared. Okay, so let us go into a little bit of detail about expunctions versus non-disclosures. An expunction. Like I stated, an expunction, if the order is granted by the court, it will completely destroy any record of that offense and make it as if it never ever existed. And the order will be given to all of the agencies that have access to that record, and they will have to go ahead and destroy that record. Now, how is one eligible for a non-disclosure? Well, you could have an arrest that was made, but that person was never charged. Sometimes what happens is the arrest is made, and then the police refer to the prosecutor, and the prosecutor decides that they don't want to proceed. The most common way that you will see someone be eligible for for an expunction, and you'll see almost all of the ones that you are going to be drafting are going to be eligible because of this. It's because the case got outright dismissed. There also could be a deferred prosecution, or a deferred or a pretrial diversion program that was completed. Um, those are also reasons why you could be eligible for an expunction. You could have gone to trial and you were acquitted. You would be eligible for an expunction like for that as well. Maybe you was charged by mistake or pardoned. Now, to be completely honest, although those are two ways in which one can be eligible, I've never seen it. They're completely rare in the state of Texas. It's like finding a unicorn. You are not going to see these two reasons in any of the documents that you're going to be drafting in this clinic. And I have never seen it, but those are two ways in which you can be eligible. And also there is a relatively new law that got passed that allows a conviction for an unlawful carry of a weapon charge to be expunged. Now, in all of this, these are the substantive ways in which you can be eligible. However, before you can actually apply, you have to make sure that the statute of limitations has expired. In the event you have a case where the statute of limitations has not yet expired, we always do have the ability to request from the prosecutor that they will allow us to proceed with an early expunction. However, if you make that request, it's really up to their discretion as to whether or not they're going to agree. And if they say no, you don't have any recourse until the statute of limitations expires, when you will then be able to apply without any issue. And it's chapter 555 of the Texas Code of Criminal Procedure that it discusses all things expulsion, if you are interested. Now, the next is non-disclosure. The non-disclosure order, if granted by the court, does not destroy the record like the expunction order will. It will seal the record and make it so that it really can't be viewed by most parties. Now, I say most parties because if a person is going for a job, and like the average employer may go ahead and use a service to do a background check, that should not pop up on that background check. That employer does not have the right to go ahead and view that record that has been sealed. But there are certain entities that will still have access to that record, even though it is sealed. So, for example, the police, any law enforcement agency has access to that record still. The courts still have access to that record as well. And there's an unfortunate reality in this whole process that it's not a foolproof process. So there are those same private companies, they have access to your criminal record because the criminal record is public. So a lot of times these background check companies will go ahead and they'll just buy records in bulk from the clerk's office. And because they're private companies, we are not aware of who they are, and we cannot, so we don't add them to any petition because we don't know who they are. So then put them on notice of the request that we're making to get their record sealed. So in essence, if we are successful with getting a client's record sealed, but we don't put that private company on notice, and they do a background check and their information is out there, we didn't know, so we can't stop it. However, the client will then have, an order stating that it's supposed to be sealed, and if we find out, we can then make them seal it, but it's not a foolproof process. Now, in order to determine if one is eligible, there are two things that we're looking for. The most common way, and the way that you all will see in any of the non-disclosure petitions that you may draft in this clinic, is because they completed a deferred adjudication. Um, the other kind of common way is the first time misdemeanor, which we also call the only misdemeanor. That really works when there's like only one offense on your record and it happens to be a misdemeanor offense and it happens to be a conviction of that misdemeanor offense, then we can get it sealed. You see that a lot, just with marijuana charges. It may just be that one person had a misdemeanor marijuana charge. It was the only charge they had on their record. They received a conviction on it, but they're eligible to get that case sealed. Now, in regards to non-disclosures, there are barriers to non-disclosures, and it makes determining eligibility a little bit more complicated, and it's unfortunate that a lot of people are going to be barred because they did not pass the barriers. So, for example, there's a waiting period that has to be completed in order to determine whether or not you can apply for a non-disclosure. So, and in that waiting period, you also cannot have another offense that results in either a conviction or another deferred adjudication. If you do, then you're barred from getting that original case that you wanted to get sealed. So, for example, if someone completed a non-disclosure, if someone completed a deferred adjudication and their case was officially discharged from court on January 1st, 2000, that means if the offense was a misdemeanor, there is a 2-year waiting period that has to be completed before someone can request a non-disclosure. That means if the case, and it starts from the day the case got discharged from court. So if the case got discharged from court from a deferred adjudication on January 1st, 2000, that person will have to wait until January 1st, 2002 in order to go ahead and apply for that non-disclosure. If it was a felony offense, they have to wait 5 years from that discharge date. So they couldn't apply until January 1st, 2005. Now, in that time period between January 1st, 2000 and 2002, or 2005, depending on what the offense was, you cannot get another offense that results in either a conviction or a deferred adjudication. If you do, then you cannot apply for that non-disclosure for that offense that was discharged on January 1st, 2000. So when we are looking at eligibility, we are looking at someone's entire record. We can't always just look at each individual offense by itself because one offense can impact the eligibility for another offense. There's also a list of ineligible offenses that will prevent someone from being eligible for a non-disclosure for anything on their record, even if it would be eligible but for that offense. So, for example, any family violence offense on your record would make you ineligible. If you had an offense on your record regarding abuse of a minor or abuse of an elderly person, that would completely disbar you from any eligibility regarding non-disclosures. So even if you had a marijuana offense that you wanted to get sealed through the non-disclosure process, but you had a family violence offense on your record that was either a conviction or a deferred adjudication, that bars you from even applying for that marijuana offense. So relatively long-winded way of explaining eligibility, but there are a lot of barriers to being eligible, especially for non-disclosures. However, the good thing is you all don't have to worry about that right now for the purposes of our clinic. It's just going to be about drafting, which we will start discussing now. So you all will be given access to a case management system that we use for purposes of clinic. It's called Box. And we have all the documents that we have used in order to make our determination in the box folders. And shortly I'll go ahead and show you what that looks like. But here's kind of what we use in order to make a determination. There could be an intake form that we have. A lot of times that happens if someone has applied online. They fill out our intake form that has some of their information in it. Sometimes we use that information to go ahead and make our determinations in terms, or I'll say we'll use that information when we draft sometimes because it may have their personal information in there. But in order to really make our determination of eligibility and the things that you are going to be looking at just to verify when you are drafting are going to be criminal records and the criminal history report that we receive from DPS, that is in regards to that particular applicant. Now, when we start this whole process, we inform people that when they are applying for our services, they have to provide us with a copy of their criminal history report from DPS. We use that report to find out all of the offenses that they have in Texas. And that report will show all the information that we need for our petitions. It will show when the arrest date was, who the arresting agency was, when the event took place. It'll give you information regarding the DPS tracking number, which is very important because we need to include that on our petitions, and I'll show you shortly. It also includes the offense, it includes the court, it includes what ultimately happened in that offense, and it will go ahead and give you the dates of all of these things as well as the cause number. So all of the pertinent information is in the DPS history report. What we do, though, is we go ahead and request the records for those particular offenses from the courts or the clerk's offices. Either we request it directly from them, or they have an online portal that we can go ahead and pull the records from. And we use those records to verify what is in the DPS report just to make sure that everything checks out the way it's supposed to. But the DPS history report is really going to be guiding how you draft. And just so you guys also know, when I had gone through the DPS history report to go ahead and make the eligibility determinations, I picked out the ones that are eligible, and I've created a Word document for each of the applicants. It's called, whoever that applicant is, it says eligibility. So in that Word document, it'll explain what they are eligible for, what county they are eligible for. It'll also give you the event cycle that I'm referring to and the cause number, the offense. It'll give you all of that information. So that's the first place that you'll look to determine what you have to draft. And then you can look in the criminal history report just to verify all that information, as well as the criminal records, just to go ahead and verify as well. So this is just a kind of a copy of the first page of what you would be looking for the DPS history report. We get the clients to go ahead and or the applicants to go ahead and send this. Just so you all are aware, you get the criminal history report through a third-party provider called Identigo. And you have to go to Identigo. There is a $25, $26 fee that they have to go ahead and pay. And you get fingerprinted, and then they pull up the report and they provide it to you, or they provide it to any other party that you may list. So sometimes we just have them list us directly, so it will come to us. Okay, so this is a copy of a criminal history report. We have blacked out the name of this particular person and the face and all of their pertinent information. But on this page will show the biographical information of the person, which is important because that's one of the first things that you're going to be asked to include in the petition. It's going to be the person's name, it's going to be the person's race, their sex, it's going to be their date of birth, it's going to be their driver's license number and their social security number, which is all going to be listed here. We'll need to go ahead and add all that information to the petition. So you may see, if you look up top right here, it'll show that, it says name, and you may see that there's a couple of different areas that have been blacked out. A lot of times they have more than one name that the person may have gone by. So we want to go ahead and include that person's name and any other name that's on this DPS report as a also known as. So there will be no issues regarding if they have the correct person or not. But you also see here, and on the next screen, you'll see that's going to be an event cycle. After you see the biographical and demographic information of the applicant, it starts the actual arrests. And the arrests are all called event cycles. Now, just so you know, and it'll make a whole lot more sense once you go into the Word documents that I have drafted. Sometimes you have one event cycle, which is one arrest, but there were more than one offense that took place during the same event cycle. And we list them as event cycle 1 or event cycle 2, but it'll be offense 1, offense 2, offense 3. So you know that it's all part of the same arrest, but a lot of different charges came out of this arrest. So this is a copy of a DPS report for the event cycles. We have taken this person's name out and we have put Sarah Mays. Don't worry, this is not her record. This is just her name that's been put into it, so we can go ahead and preserve the client who we took it from. And you'll see event cycle. This is event cycle 3. You'll see this right here. Right here is the tracking number. This is the DPS tracking number, which you will need to add in the petition. It gives you the arrest date. It gives you the agency that did the arrest. In this case, it was Round Rock Police Department. And then you'll see tracking suffix A1. That would basically be like, okay, what we would consider offense 1. If there was multiple offenses, it'll be A2, A3, A4. You'll see here that it gives you the offense date, which is here, it's 8/8/2013. It gives you the offense type, which was theft of property. It even gives you the level of degree of what the offense was. In this case, it was a misdemeanor. It will go ahead, you'll see the prosecution was Williamson County Attorney. They accepted the charges. And then if you go down to the next level, it says court data. You'll see that the court was County Court at Law 2. This is the offense that proceeded in court. It's still the theft of property, so they did not change the charge. And you'll see ultimately it was dismissed. And it was dismissed on 1/5/2015. And this other highlighted number underneath that is the cause number. All of that information you will see. That is all very pertinent. We will make that determination that, okay, we reviewed this. This case is eligible for an expunction. Now, the statute of limitations, we have to go ahead and think about that. Statute of limitations for misdemeanors is 2 years. So it ran already. We are okay to go. So you'll see here at the top, event cycle 3, Williamson County, that's an expunction. Now, what is not listed here is event cycle 4. But we would have reviewed that and say, oh, you know what? There was a deferred adjudication that was completed, and the time period for the waiting period has surpassed. This person is eligible for a non-disclosure. And that information will be in that snapshot on the Word document that I've created to explain to you what the eligibility is. So, like I stated, we also request court records so we can go ahead and just verify what the criminal history report is saying. This is an example of some of the court records that you may see. All the way to the right is a motion to dismiss. That is basically the dismissal order. Oh, excuse me. You'll see here order of commitment. That right there is going to show that the person was incarcerated. So all of these things we will use in order to make our determination for eligibility. Also, we use those documents as exhibits in our petitions. So if we are drafting a petition for expunction, we will go ahead and have Exhibit A, Exhibit B, whatever it may be, and we will go ahead and attach all of those motions to dismiss for those orders, for those cases that are that were dismissed and are eligible for an expunction. The same goes for our non-disclosures. If we have a non-disclosure that we are drafting because the person has a deferred adjudication, we want to add that order of deferred adjudication, and we want to add the order that says the case was discharged from court, because it is our burden to prove that this person is eligible. So we're using the court documents to show that. Okay, so that is all about the explaining what it is that we're looking for and what you're going to be using in order to draft. But now let's talk about the next part, the actual petition. So here is the basics. Like I stated, it is a plug and play form that you are going to be using. And there are various directions and also things that are highlighted so that you kind of can know what you need to put in those sections. So there are going to be areas in that form that you see that are highlighted in yellow. Those areas that are highlighted in yellow are just instructions about what you need to do. Once you have followed those instructions, be sure to delete that yellow area of the instructions, because we don't need that in the final product that we have. It's really a guide for you all. You will also see purple highlights. The purple highlights are, they're also instructional language, but it's really going to apply to what is going to be applicable. There are, like I stated before, there are various ways in which one can be eligible for a non-disclosure or for a expunction. So for example, the expunction could be eligible because you had a dismissal. It could be eligible because you had the pardon. It could be eligible because you had a pretrial diversion that you created. We have areas in the petition that list all of those, because it just makes sense. Like, we're not going to go ahead and draft petitions for each of those different types. We'll just put it all in one, and you will go ahead and choose the one that is applicable to this particular offense. So that's what the purple will be. The purple will be, pick which one works for you in regards to that offense, and then delete the ones that are not applicable. And then for green, green highlights when you just need to put in the information, put in the text. So for example, the portion for the biographical information, right? You'll see it'll say client name, it'll be highlighted in green. You put in that client's name. It'll say date of birth, you put in that date of birth. So anything that's green, you'll just go ahead and edit. So the first part of the petition is going to be the petitioner's information and the offense information. So the very first thing you'll add is going to be the name of the person, the date of birth, the driver's license, social security number. All of that information, remember, can be found on like the first page of the criminal history report that we showed you. That information can be found there. Once you're done adding that information, you will go ahead and start adding the information for the actual offense. So here is an important thing to remember. For expunction petitions, you can add more than one offense to a petition for expunction. So, in many of the people that we're going to be drafting for, they're eligible for more than one offense in the petition. Now, it is important to note that that's only going to be applicable for that particular county. So for example, we have a couple of people who may have like, they may be eligible for like maybe three expunction petitions. One for Dallas, one for Harris, and one for Travis, right? Any of the offenses that are for Travis County, if there's more than one, they can all be added to that Travis County one. The same thing applies to Dallas. The same thing applies to Harris, right? So that's very important because each time that you list an offense, you'll have to go ahead and list the reasonings for those offenses too. We'll go into detail about that momentarily, but you do have the option of putting more than one on one petition. However, you don't have that option for non-disclosures. Non-disclosure, it is one offense per petition for the non-disclosure. Also, it's important to know, like I was stating earlier, if that person has more than one name that's listed on their criminal history report, you want to go by the name that that person goes by first and then list all the other ones as also known as. The same thing may go for that person's race. There are a lot of times where, you know, you may have a situation where the DPS report lists that person's race as white, but that applicant has informed us that they identify as Hispanic. So you want to list both what is listed and also what that person identifies as. And you will just say, you know, also this person is listed as this, but also identifies as this particular race. So that's just also important to know. So here's kind of an example of what we're talking about when we use the different colors. So you'll see on the right-hand side, the left-hand side of the screen for the expunction, you'll see that this is yellow language, so it is instructional language. And you'll see it says, if charges were filed and dismissed, and the statute of limitations has run for all offenses except Class C misdemeanors, which is charged by the complaint. So you will then have to go ahead. This is what you have to pick, right? That's how you know this is the one that you want to use. So off to the non-disclosure side, you'll see purple. Oh, let's go back. Purple, green, and red and yellow. Now, like I stated before, there are various reasons why you can have a non-disclosure. One of which is because you had a deferred adjudication. So that is where the purple comes in. You have to pick the one on the petition that states deferred adjudication, not the one that states conviction, if that's not how it applies. And then this is the instructions for the cases that are applicable because there was a deferred adjudication. So that's the area that you want to fill out. And in the green, that's when you start to go ahead and just edit. So it says on green is date of plea. You put that date on there. Guilty, no contest, nolo contendere. You choose which one's applicable. The cause number, you put that one in there. So that's how you go ahead and use the petition. We call it choose your own adventure. And I will show you how to do this shortly. So I know this may sound a little bit daunting, but it's really not. And the last part regarding drafting really is the agencies. So you did hear me state a little bit earlier that, you know, the agencies have a certain time period in order to go ahead and comply with whatever the order is. There are 3 standard agencies that we have in every petition that have access to your record. So one of them is DPS, right? That will always be standard. However, you want to put the agencies that are applicable to that county into that particular area of the petition and the order. So let's just kind of backtrack. How do you know who the agencies are? You have to kind of look at it through the eyes of who has touched this case, who has been involved in this person's arrest or their their the criminal records they would have accessed it. So perfect example, you want to make sure that whoever the arresting agency is, they are the first ones that started this process, right? So they'll be added to it. Um, the court, the court will be added to it because they have access to the record. The district clerk has access to the record, so they're going to be added to it. The DA's office for that county is going to be added to it, and so on and so forth. We have a bank of agency lists that we have created through the course of our time doing these types of cases. So we have a vast number of agency lists for counties already done. I do not believe any of the cases that are going to be drafted don't have one that we've already created. This agency list I've already placed in the box folder. So all you'll have to do is go to the box folder, which I will actually show you right now. So before I do, is there anyone that has any questions about anything before we continue? I know that's a lot of information. Yes, Vanessa.
Will we be interacting with the actual clients? And if so, do they already know what charges they're eligible for from expungement to non-disclosure?
No, you won't be interacting with the clients. It's just a matter of just drafting it. And then what we're doing is we're drafting these petitions for them to actually submit pro se. So they'll be doing it on their own. What we'll be doing after it's drafted is we will go ahead and then send them the information that we've drafted in this clinic so that they have everything that they need to go ahead and file on their own.
Okay. And you mentioned that with expungements, you can list multiple offenses. Do they have to be confined within specific arrest, or could it be just offenses? Okay.
No, it doesn't have to be within that arrest. It is anything that you are eligible for that county that's an expunction can be added to that petition. And then you have to look at it as like, it's really for judicial economy, right? You have a situation where somebody can have 10 offenses in Dallas County that they got dismissed, or maybe there was a pretrial diversion or whatever it may be. They're eligible. It just makes sense for you to put all 10 of those on there so you don't have 10 different judges dealing with the same person. It's all going to go to one judge and they can handle it all at once. And then on the flip side, for applicants who are not eligible to receive a waiver, if you had to go ahead and do 10 separate petitions, that is a lot of money where you can put all of those in one petition and then just pay the $300 fee for filing if you can't get that fee waived. So in the interest of judicial economy, courts and counties have allowed us to do more than one expunction eligible case in one petition. Now, the reason why you can't do that for non-disclosures is mainly because of how it's filed. The non-disclosure, when you are drafting the non-disclosure petition, you are going to be using the cause number that is the actual criminal cause number. And it gets filed in that court that heard that petition. Even if that judge is not the same judge anymore, it goes straight to there. And I think they look at it as like, we want to go right back to the source and have this judge make a determination as to what we're going to do with this case. Whereas the process for filing for expunctions is different. You don't know the expunction cause number. It's going to be a separate cause number that's going to be given once you file it with the court. So, and I'll show you in a second when we go ahead and do like the drafting that you don't want to go ahead and put the cause number at the top of the caption because we don't know what that expunction cause number is going to be. But once you file it, it gets filed into a district court, and whoever is basically on the wheel, whoever gets it gets it. You don't know who's going to get it now, so you have the ability to put more than one in there. They're not treating it like you're filing it into the actual underlying criminal cause that you are for non-disclosures. So that's
it's a new case.
The brand new case for expunction, and not for non-disclosures.
Cool. Thank you.
You're welcome. All right, so let's go to box.
Vanessa's a former prosecutor, so she's less intimidated by this than all the rest of us.
Sorry, I've taken so many notes. I'm super fascinated, but I know we have an hour, but I do have a lot of questions and I probably will continue to volunteer. I'm really psyched.
No worries. All right, so um sorry, let me just go back to Zoom. Okay. In a moment, you'll see my screen. This is going to be Box. I have all of your email addresses. I am going to go ahead and basically send you all links so that you will have access to view Blocks. You will see that in this folder, the applicants folder, we have subfolders of all of the applicants that we have that we're going to be drafting for. Within each of those subfolders, you will have that Word document that I stated that has their eligibility determinations. You will have their CHR, which is their criminal history report. You will also have any of the applicable case records that are going to be applicable to those offenses so that we can go ahead and add them to the petitions. Now, this drafting templates folder is where you will find what you need. You will have a copy of the non-disclosure template, a copy of the expunction template. This expunction exhibit, that is going to be added to the expunctions as an exhibit. It is a blank acknowledgement form. So let me kind of just explain what it is and why we use it. So we send with the petition as an attachment, as an exhibit, a blank form that is supposed to be given to all of the entities that, will get access to this order, knowing that they have to do whatever they have to do, whether it's sealing it or destroying it. And it's supposed to be filled out by them to say, we did this. And then they're supposed to give it to the clerk's office. Now, the reality is, when we file these, there's no real way for us to continue to find out if they have done what they're supposed to do after we're done with it. So we do always inform our clients that, you need to go ahead and just be on the lookout. You have a copy of this order, so you know that the court did state that this needs to be done. However, pay attention if you happen to go to a job and you have an employer that does a background check. If that case is on there, let us know, because now we can go to them and say, oh, this is supposed to be sealed or it's supposed to be expunged. We have this order. You have to go ahead and do that. So that's why we add it. It's supposed to be for that agency to fill out and submit back to the clerk's office. But this, you'll see the subfolder. It says CRC, which is criminal record clearing, agency lists. And we have the agency list for a number of counties. So all the counties that I believe that are going to be you're drafting for should all be in here. But here is an example of, let's say we'll use Harris County as an example. So you'll see, like I stated, the first three are going to be the same for every case. So we don't have to make them county specific. It's DPS, Department of Criminal Justice, and the Office of Court Administration. But then we start to go into that particular county. And you have to just kind of think about who has access to your record within that county. So of course it is, we have County Central Technology Services, we have HPD, Houston Police Department, Harris County Sheriff's Office. Now, these are all pretty much standard too for your county, like the sheriff's office for that particular county and all that stuff. But if in fact the arresting agency that made the arrest for that offense is not on a pre-existing list, you have to add it to the petition and the order. And we could easily just go ahead and Google that person. So if it happens to be a Harris County petition that you're drafting, and it just happens to be the constable's office, right, for precinct 5, right? You can go ahead and just Google that information, and then we can go ahead and add it to the list because it might not be there already. And it's going to be the same for expunctions and non-disclosures. You just want to make sure that when you are copying this list for a non-disclosure, this area that says attention expunctions, you just want to change that to attention non-disclosures. And then also going back to the templates for expunctions and non-disclosures, this is more of just a reminder. Each of the applicants is going to need to have one of the other in their particular box folders. So please just basically copy and paste that or download it into that particular folder and don't draft within there. I know that's one of those things that's like of course you're not going to do that, but I've actually had people do it inadvertently. So just be sure to take that and make sure you put it into that particular person's box file when you are drafting that information. So this is what you'll see in Box. Once I receive all of your volunteer confidentiality forms, I will go ahead and then send you the link to Box, and you can go into it and start exploring on your own. So do you have any questions about Box? Okay, so now let us go ahead and just start. I'm going to show you how to draft at least partially so you can kind of get the hint of it. I know we're running out of time, so I apologize. All right, so this is a copy. This is what you'll see for an expunction template, okay? Now, this is just a sample that we have for Travis County. So of course, it's green. At the top, you don't want to add a clause number, not for expunctions. For the non-disclosure form, you can add that, and you can also add the court that the underlying criminal case was heard in here in this section regarding the court for non-disclosures. But for expunctions, you don't want to do that. You want to leave this clause number blank. You want to leave this little area that would be the number of the district court, leave that blank, but you do want to change whatever the county is to the applicable county. Also, where it says ABC, what we like to do is we like to go ahead and just put the initials of the applicants in the caption. So whoever that person is, put their initials there, but underneath you'll see you have to put that person's full name. And then following any of their arrests, right? Now we go into the applicant information. So you'll see it's in yellow. This is, explaining what you need to do. This is the instruction area. Once you follow the instructions and you're done, you want to go ahead and delete this portion that's in yellow, okay? Now, the same thing goes for here. See, A is identifying information. You want to go ahead and put that person's full name and then also list any AKAs that they may have. And what's in yellow is an example of that for the instruction purposes. You change, their sex, whatever their sex is, their race, whatever it says on DPS, but if they identify as something else, you can go ahead and also say also this. And then you start to go ahead and put that person's biographical information in, like their date of birth, their license number, and their social security number. Remember, all of that information is found on the DPS history report on the first page that talks about that person's biographical information. Now we go to the offenses, and you'll see here in yellow, it says if only one event, then just change to offense information. So if that person's only eligible for one charge, we don't have to worry about saying event 1, event 2, event 3, event 4. But if they have more than one charge, then we'll leave it as event 1, event 2, event 3, event 4. And then you start adding in the information that's in green. All of that information is also going to be in the DPS criminal history report. You'll see here that it says petitioner's address at the time of the arrest. Now, sometimes on some of the documents, you'll see it specifically for Harris County, it will list the address of the person at the time of the arrest. But most times we don't have that information. So this is the one thing that you can put on the petition that says, I don't know, and you'll be okay. So you can say not applicable. No, actually, I'm sorry. You could say unknown. You want to add the arresting agency, the cause number, and now is where you want to go ahead and like pick which one that is applicable, right? Is if no charges were filed in court, if there was a no bill. So this is when you have to figure out which one's applicable and only use the one that's applicable and not the rest of them. Now, this is, you have to look at it kind of in two parts. It is, what's the offense? What's the reason the offense is eligible for an expunction? That's the reasons applicant is eligible. That's part two. Now, just to kind of go ahead and backtrack a little bit, before you get to part two, you need to go ahead and put all that information for all of the different events in part one. So if you have 3 offenses, it'll be event 1, event 2, event 3, and then you'll get to section 2 that talks about reasons that are applicable. And just as FYI, you will do the same thing. It'll be event 1, event 2, event 3 for each one of the ones that are applicable. And so that's why this is in green, because you may have to change it, right? But now we go into the reasons why, and that's why you'll see yellow and you'll see green, because there are various reasons as to why the case could be eligible for an expunction. So if it's a felony or a Class C A/B misdemeanor that was dismissed, honestly, this is the one that you will probably use the most, okay? Now, if it is, there are a couple of cases that I do recall where the case was, the arrest was made, but the charges were never brought, and there is no cause number. So in a case like that, it would be that it was never Class C misdemeanor, or the case was never filed. So you would use this section, right? So that's the area that you have to go ahead and pick which one is applicable. And then you want to do that for each event. So that'll be event 1. These are the reasons why it's applicable. Event 2, these are the reasons why it's applicable. And then when you're done, you get to the 3rd section, which is the agency case list. So of course, these are in yellow, which means when you're done, you can go ahead and delete that information. It's just the instructional information. And you'll see 1, 2, and 3 are already on this document. In this area here, you will go ahead and cut and paste whichever list is applicable to that county, and you'll use the rest of those agencies, put them in this section. And this is for private entities, which we don't necessarily have in any other ones that we use. And this is finally your request for relief. Now, the applicant's name you'll add here. We can add the applicant's address later on, so you don't have to worry about that right now, and they're going to be filing it pro se. Now, this document has all that you need. So it has the declaration. You want to go ahead and put the correct information in for this declaration, and we'll have the applicant sign it. We also have the notice of hearing, so you want to change the caption for the notice of hearing. This is going to be filed with the expunction petition as well, because this will give us, or the applicant, when they file it, it'll be signed by the court and they'll know what date the hearing is, if it has to go to hearing. And this is the order, all right? So once again, you want to change the caption information. You want to go ahead and literally it'll tell you here, insert paragraphs describing the reason the applicant is eligible for an expunction from the petition. It'll tell you where. That's when you want to go ahead and literally cut and paste into these respective sections for your order from the information you already put in the petition. And then it'll go right back to the agency section, which you'll see is right here. Copy and paste that same agency list. And ultimately, if we're granted by the court, this is what the court will go ahead and sign off. So that was brief, but you'll see everything is highlighted. Everything is literally like, here's the next steps. So once you kind of read through it, you'll get more familiarized with it. And it's just plug and play, put the right information in, delete what's not applicable, and then you kind of move on that way. And hold on, so a couple more things and then we'll done. Okay, so we talked about the agencies, did the demo. Oh, and this is just a brief like explanation. Remember, I said it's very expensive. Our clients are eligible for a fee waiver because they would be deemed indigent by the court. So we're also going to provide them with, they already filled out what it's called as the statement of inability to pay form. So we'll also give them a copy of that for them to sign and submit that to the court. But for those who are not eligible to get any of the fees waived, it's about $250 to $350 in order to actually file a petition with the court for non-disclosure or for expulsion. This is a copy of the statement of inability to afford court costs that we already have the clients fill out in the beginning of this process. So we basically just ask them, like it asks you if you have any dependents, if you're on any public services, if you receive government benefits, and it asks a snapshot about what their financial picture is. Are they employed? Do they receive unemployment? Do they receive any money from any other person in their household? What their assets are, what their expenses are, what their debts are, and provide that to the court. The court will accept it and waive any of the filing fees. So this is just a brief explanation about anything that we have upcoming. We don't have any particular clinics that are upcoming. We are kind of in the process of working on a clinic with the National Urban League in Harris County. So I will definitely reach out to you all if we get more information about the need for volunteers for that. But we do have a pro bono program if you all are interested. It would be basically, we estimate anywhere from 5 to 7 hour commitment per record drafting petition. That's like in total, right? For any representation. It would be direct representation for that particular client. Of course, there is TFDP staff support. I am the person that runs the clinics and runs the pro bono program, so we will be able to answer any questions. We have tons of templates, checklists, forms, a lot of training that's available. This is a copy of the link for the Google form if you are interested in actually volunteering and signing up. And these are also some other opportunities that we have. Not only do we have record clearing opportunities for our pro bono program, we also have Class C ticket restoration. We are part of the Clean Slate Coalition for Texas, where we're trying to advocate in the legislature that different laws that we believe need to be, changed so that we can go ahead and just have more opportunities for Texans to clear their record. And of course, we have other volunteer opportunities that may be available at later dates. So does anyone have any other questions before we end today? And I am sorry that we did go over.
Sorry.
Sorry, go ahead. I was just going to ask, during the actual drafting session on Wednesday, do I have it right that if we have questions as we're going through that we'll be able to ping you or someone else to get kind of assistance while we're doing it?
Yes. So what we'll be doing is it's all going to be on Zoom. Everyone's going to be in their own little like Zoom room, right? Where you can go ahead and take all the information that you'll have access to, a box, draft the petitions. I know that you all will have questions. Both me and Sarah May are going to be in this in our, I guess it'll be the main room, if not like the Zoom room or whatever. But yeah, you can go ahead and just let us know that you want help and we will both be able to assist you. So yes, we will both be present.
Okay, great. Thank you.
You're welcome. And like I stated, once I get the volunteer confidentiality forms back, I will give all of you access to what's in Box. And you may want to just go ahead and just look it over to familiarize yourself with it so that you kind of are not like completely inundated with it once we start. But that's what we're going to be using, and you'll have access to see everything. And if you don't, for whatever reason, have access, because you should, once you get, I have your email addresses. So once I give you that link, it should be fine. Just let me know, and I'll try to fix it before Wednesday.
Sorry, Yvonne, a couple of times you mentioned if the court accepts the petition. Is there something, assessment the court is making outside of the four corners of these petitions to like determine?
Well,
whether or
no,
not-
then maybe I should have clarified. It's not about if they accept the petition. I really wanted to say if they grant the order, but not accept.
Right,
the
is there
petition.
some type of evidentiary, like what would, if they meet all the eligibility requirements, what would make the court say no?
So for expunctions, the court can't say no. The court shall do it, but it doesn't mean that the DA won't contest it. Now, realistically speaking, the only time that I've ever had a DA ever contest a expunction request, it was actually my fault. I filed it just like a couple of weeks before the statute of limitation had expired. And that was their only reason why they were contesting it. So it was like, okay, we fixed that. But other than that, I've never had a DA contest an expunction, right? So there is, if you meet the statutory requirements and the statute of limitations has already told, there's really no reason why the court should go ahead and not grant it. And the statute says the court shall grant it, so they have to grant it. The difference is the non-disclosure. The non-disclosure is going to be at the discretion of the court because the court has to go ahead and they conduct like it's in the interest of justice standard. That's what they're using. The court does not have a requirement that they have to grant the non-disclosure, even if statutorily you meet all the requirements. And that's when you may have a situation where the DA may contest it for whatever that reason is. I've had DAs contest it simply because it was a serious charge. Yeah, but even though it was a serious charge, they still meet the requirements. So then you would have a hearing at that point, and you would all make your case, and the court will go ahead and determine what they're going to do. But it is in the discretion of the court not to grant the petition or not to grant the request for a non-disclosure, but not for an expunction. Are there any other questions? All right. Well, I am very excited about Wednesday. I will see you all then. And like I said, just look out for an email that will say that you have been invited to Box. So, all right. Well, thank you all for your time. And once again, I do apologize for going over.
Thank you very much.
You're welcome. You have a good one.
You too. Bye.